Hi, everybody. Welcome to Trial Alchemy. I'm your podcast host, Monty McIntyre. I've been a California civil trial lawyer since 1980 and a member of the American Board of Trial Advocates, ABOTA, since 1995. These days, I help lawyers get excellent results, first by helping them settle cases as a mediator. I also decide cases as an arbitrator, and I also decide issues as a referee, and I do this work with ADR Services. I also help lawyers save time, know more, and win more cases by making it easy for them to always know the new case law in their practice areas with my online publication, California Case Summaries. And this publishes one-paragraph summaries of every new California civil case published throughout the year. And finally, with this Trial Alchemy podcast, I help both experienced and inexperienced lawyers become good civil trial lawyers by interviewing outstanding plaintiff lawyers, defense lawyers, and civil trial judges who are all members of ABOTA. We talk about what works and what doesn't work in civil jury trials. Now, today I'm delighted to have as my guest Christopher J. Beeman. He goes by Chris. And Chris has been throughout his whole career with the law firm Clapp Moroney, and they're up in San Francisco area. He's a nationally renowned trial lawyer, and he leads the law firm's personal injury and business litigation groups. Chris belongs to and is active in the following prestigious organizations: ABOTA, the International Academy of Trial Lawyers, the American College of Trial Lawyers, and the International Society of Barristers. Now, all of these four groups are invitation-only groups, and they recognize lawyers from both sides of the aisle who have successfully tried numerous cases to juries, who are excellent trial lawyers, and who also exemplify professionalism and civility. Chris is a past president of the San Francisco chapter of ABOTA, and recently was the national president of the ABOTA Foundation. In 2022, he received the San Francisco chapter's Don Bailey Award for Civility, Professionalism, and Integrity. And in 2023, he received the San Francisco Trial Lawyer Association's Distinguished Defense Trial Lawyer of the Year Award. Now, Chris has been with his law firm his entire career, and his current practice emphasizes the representation of individual and corporate defendants in cases ranging from catastrophic injury and wrongful death claims to business litigation and professional liability matters. Chris has tried to verdict cases brought on behalf of more than 100 plaintiffs. So without any further ado, Chris, welcome to Trial Alchemy. I'm delighted to have you as a guest today. Thanks for joining me.
My pleasure, Monty. It's good to connect with you from the confines of Pleasanton, California today.
Well, very good. So, Chris, let's start off with this. You've tried a lot of cases, and what is one of your satisfying trial victories that you can share with us?
Let's see. I was thinking about some of the cases I've tried. I guess probably the one that might be semi-interesting to the listeners is a rather unique fact pattern. I think we've all tried lots of brain injury, wrongful death, people falling off of building cases, and those are all obviously can be very interesting and entertaining at the same time. The case that I suppose I have a little bit of infamy for is a case that involved an egg ranch that was in the Central Valley up here. And with the price of eggs today, I think my client wishes he still had that business operating. But this goes back about probably 7 or 8 years, or maybe even a little bit longer. And if I can make it a short story, it basically was a nuisance case. And it was brought by about 30 neighbors of this egg ranch out in Lathrop, California. And very agricultural area. And it's the reason I'm pausing a little bit is there's hardly any nuisance cases that are actually tried in front of juries. I learned a lot about, I think, trying to keep an otherwise maybe boring case modestly interesting. But the story is that the way this came to me, an insurance claims representative called me up on the phone and said, Chris, are you familiar with the right to farm defense? And my response was, well, of course. And of course, the of course was I had to look it up to figure
Right.
out what right to farm meant. But there were some people that lived in houses in this very agricultural area around the chicken ranch. And if you think about it, chickens lay eggs. Chickens also do something else, which is poop a lot. And they also generate dust, feathers, things that would be really annoying if you lived nearby.
Right.
Something that was interesting about this particular property was it was they had what was called a manure lagoon. Um,
Wow.
so it was not a typical case, and the neighbors sued for the nuisance and the diminishing value to their property. And the right to farm defense basically says that if you conduct your farming operations similar to other businesses in the locale, then you have the right to do that. And of course, we benefit from having chickens and eggs and all other kind of agricultural products that sometimes can be rather annoying to the people that live around the properties. So it was a very fascinating case. It went on for a really long time. It was about a 2-month trial in Santa Clara County. I did recruit one of my partners kind of on the eve of trial to handle the damage as part of the case. And there's a lot of stories that I could tell, some appropriate for a podcast, others probably not. But I will say one short story about the trial team that tried the case for the plaintiffs. There was the Hall of Fame, literally somebody in the Trial Lawyers Hall of Fame in the Bay Area who tried the case. There were several ABOTA members from across the country, one from Kansas City, one from outside of Georgia. And we were doing the in limine motions. And mind you, this is in Santa Clara County, which is anything but agricultural. And so we were all kind of getting used to each other. And the judge was trying to get a handle on the legal issues that were unusual.
Yeah.
And one of the local flavor lawyer filed a motion in limine to prevent our team, the defense team, from referencing the fact that there was a lawyer, the lawyers were from outside the area and were basically carpetbagger. It was the anti-carpetbagger motion. And the lawyer who was the primary trial lawyer from Georgia had a very deep drawl and talked like this, Your Honor. And we all kind of got a chuckle out of the fact that there was a motion that that had been filed to make sure that we didn't communicate to the jury that he was from out of town. And the judge had a little, the judge had a little laugh, and he's a really good judge. And he said, well, don't you think that as soon as he opens his mouth, everybody's going to know that he's not from around here? And we were all in good spirits at the beginning of that trial. And I said, Your Honor, I'd actually like to join this motion and ask the court to prevent this lawyer from ever opening his mouth during the trial. Right. So we get a little chuckling. And the lawyer, to his credit, really good guy, really good trial lawyer, he says, Your Honor, I have 3 ex-wives that would stipulate that I should never open my mouth. So I went into that case as a trial lawyer, and I came out of that case. I forgot to mention one thing. The chickens generated more than a ton of manure per day.
Oh
So
my God.
it was a nasty case. But I went into the case as a trial lawyer, and I came out, unfortunately, known as a chicken shit lawyer after that. So, but it was an interesting case, really good lawyers. And sometimes you get cases that you can't even imagine would be filed, but that was one of them.
Yeah, that's unusual, not run of the mill. I remember there used to be a chicken farm in kind of a rural area, but they still had a lot of homes around it in San Diego. And depending upon where the wind blew, you could really smell that thing. So I imagine you had some of those issues in your case.
Yeah, for sure. One other story about that case, just because it was interesting, because I mean, most of the cases that I've tried, primarily in Northern California, although, San Diego, Central Valley, YOLO. So I mean, Greater California, but most I live in the East Bay of San Francisco, so most of the trials are, in the Bay Area counties. But trying a case against somebody from particularly a different state or a different jurisdiction, it's very interesting because things that I've always heard good trial lawyers try to familiarize themselves not only with the judge and the bailiffs, obviously, but also with the venue, getting
Yeah.
to understand kind of what the plate where they are traveling is all about. And the lawyer that I mentioned, who was from out of state, he referred to Ghirardelli chocolate over and over again as Ghirardelli chocolate. And it was almost like, having a stamp on your head saying, "I'm not from here." Uh, he's
Oh,
still.
that's funny. Well, listen, you've been an ABOTA member for a long time, and you've served as the National ABOTA Foundation president very recently. So, and you're a member of other very prestigious groups. But let me ask you this question. So, why is ABOTA important to you as a civil trial lawyer?
Well, I came up, and I've been with the same law firm as you mentioned. I've been here my entire legal career, and our senior partner, Dwayne Clapp, who's now retired, he was an ABOTA member when I was a baby lawyer, and so we learned early on what a prestigious organization it was and what an honor it would be to get into that group. And so that was a goal that I set as a young lawyer to try enough cases to be able to hopefully have somebody nominate me, which then later did happen. And the organization, I think, and this goes for the other groups. I'm more active in ABOTA than the others, although I try to go to events that the academy has and that the college has and that the barristers have when possible. I just kind of, ABOTA is a little bit more local, so it's a little easier to become involved in. And then when you become involved in the local chapter, if you're interested in broadening your horizons a little bit, you can obviously attend national meetings and regional events as well.
Right.
And it's been a really great source of friendship, camaraderie, dealing with peers that you learn more about by not always arguing with them in a courtroom. And I've really enjoyed it. I really value the relationships that I've made, and I've learned a lot from the people that I have dealt with. And that goes the year that I was the foundation president, that was 2023, obviously kind of coming out of the pandemic at that point. And one of the things that we spent a lot of time on was presenting professional seminars for continuing legal education for lawyers, and not just ABOTA lawyers, but really for anybody who was interested in hearing somebody talk or watching somebody give a demonstration about some piece of trial. And I attended every one of those. I really learned a lot by listening to other lawyers, some that did what I do, and a lot of people that are on the other side of the V that have a whole different bag of tricks than the defense lawyers use in our industry. And it's just been a really great forum to get to know other lawyers better, and also to kind of broaden the horizons about what kinds of cases might be interesting to work on, and it's been very satisfying. I really enjoyed being involved with ABOTA.
Well, that's great. Thanks for your service in it. I've served on the national board and served as a local chapter president. It's a great organization and they do great work. So, Chris, let me now focus a little bit on you're going to get ready for trial. You've tried a lot of cases, you've defended a lot of cases, and every good trial lawyer is going to kind of start preparing for trial from the beginning. But there's also a certain point in time where if the case can't be settled, you realize, okay, this thing's going to trial, whether it's a few months from now or however long, and there's some final prep to try to get finally ready to go to trial and have the judge say, okay, we're bringing in the jury. So what's your process and what is your routine that you've developed over the years to get ready so you're ready when it's time to go?
Well, I think I would start by saying that a really important piece of my trial preparation is making sure that I've got a team that is available and capable and engaged in the case with me. And obviously that kind of evolves over time. I had no team, when you're trying small fender bender or auto versus bike cases.
Right.
And that's good. I mean, because it's kind of like learning from the ground up. You do your own page line summaries. Try to figure out your own exhibits. And so I think that there's definitely a benefit to, being boots on the ground, and learning how to do each aspect of trial prep. At this juncture, I have the benefit, and I guess I'm a little bit spoiled in that I haven't tried a case alone for several years now, and I really value trying a case with another competent, strong, capable lawyer, and that's become a little bit of a formula for me. And there's multiple reasons for doing that. One of them is that I'm a huge proponent of trying to get my colleagues enough points to have the admission to ABOTA be a possibility.
Right.
And so that's kind of that honestly has been a factor in who I've brought to trial with me. And I really integrate the people that I try cases with into the entire presentation. Typical right now, I'm getting ready to try a case that's in September. So, and I say I'm getting ready. It's still 3 months away, so I'm not really in the rolling up the sleeves. I'm more kind of rolling up the cuffs right now, just making
Yep.
sure. But typically, the approach to trying a case with a colleague will be that I like to pick the jury. I think that's a really important part of the case, and we could talk about that later if you'd like to. But that's usually something that I am responsible for. And along with that, if there's a mini opening, then I will usually give the mini opening.
Yep.
Typically, I have an associate or a partner give the opening statement so that they're immediately in front of the jury. And there's a couple of reasons for that. One is I'm aware that jurors like to hear different voices, see different styles, listen to different presentations as opposed to having one person be the lone wolf. So I
Yeah.
really, really try to avoid that. And in the cases, depending on what the evidence is and what type of a case it is, I make some effort to have my colleague, who I'm trying the case with, play a big role with witnesses that make a difference. So it's not just a Batman Robin thing. It's more like a Batman or Batwoman thing, is what I like to do, because I think it's important for the jury to hear different people giving perspectives. And I do all defense work at this juncture. So, having one of my partners speaking to certain issues, whether it's fault or damages or a combination.
Right.
And part of this, the reality is that I want to make sure that if I'm taking too aggressive of a position on liability that might detract from my credibility, that I have somebody else then do damages so that maybe the credibility, obviously credibility is a huge thing, and I try
Right.
to use that, but I try to kind of make a little bit of a gray line, at least, between the roles we're playing at trial. So if my partner Ashley is trying a case with me, when she stands up, the jury will know she's going to talk about damages. Or when she stands up, the jury will know that Ashley will be talking about a specific liability issue in the case, whether it's toxicology or accident reconstruction or whatever the issue might be.
So, do you have a pattern with this teams of two where you will do the voir dire, you'll do the mini opening, you'll let the other person do the opening statement, and you break up witnesses? Do you tend to do the liability more often and have them do damages, or do you mix it up?
I tend to do liability more, and
Yeah.
that's purposeful. There's a reason for that. One of them is that I like to dig into that, and obviously, if it's not a contested liability case, then we split things up differently.
Right.
I think, who examines a witness is really important. And an example is that we have a case coming up with three of the plaintiffs are, yeah, I think 21 to 14 or something like that. And I'm laughing at myself. I'm an older guy now, and I think a younger partner would do a little better job relating to the witnesses. And I obviously we want the jury to see that we're empathetic to them
Hmm.
at the same time getting into some stuff. So it is case dependent. The other thing I wanted to mention, Monty, is that the other people that play a crucial role in the trial prep. Obviously, our legal assistant is almost the captain of the ship in terms of getting us organized and just figuring out logistics. Because
Right.
for the cases that we try that are not in our county, we'll always get an office near the courthouse so that we can have basically a war room that's
Right.
nearby, so that we can have that in place and ready to equip. Our paralegal, I've had the pleasure of trying almost every case with the same paralegal, Kevin Dessler, who's been here for more than 40 years. So we kind of go way back and have quite a rhythm in terms of getting things ready and getting witnesses ready and getting ourselves organized. And then another really key player is working with a jury consultant to help streamline the selection process and keep us organized. Short war story is that we were trying a brain injury case. My partner Adrian Duncan and I were trying a case in San Francisco, and it was during the pandemic. There weren't too many cases going to trial, but this one did. I think it was 2021, something like that. And we were in a department, and as you can probably remember, what the judges were doing if you were in trial, first everybody's masked and all that good stuff, which made it
Right.
very cumbersome. But in San Francisco, they had a double department, so it was twice as big as a regular trial department. And during jury selection, they had the potential jurors out in the audience. And as you know, and others probably listening know, keeping track of your jurors, I mean, it's great if you can call them by name, but you need to know what number they are and
Yeah.
who they are. And it was very difficult when the audience there was, spacing between all the jurors, and it was even hard to see some of them. They were so far away, but we used Cogent Legal during that trial. They're fantastic. Andrew Walker is the jury consultant that kind of works side by side with me, and I've used him on at least a dozen cases. And he was so efficient at keeping track not only of where their jurors were sitting and who they were, but
Hmm.
running social media on them and doing background checks and figuring out things that you wouldn't know by looking or talking to somebody. So, having a good strategy going into a trial definitely includes making sure you're surrounded by people that you're comfortable with, that you work well with together, and that kind of everybody knows their role in the trial.
Yeah, that makes your life a lot easier when you've got a great team like that you put together. Well, let's talk about this as we're heading towards a trial. Um, Lawyers are always thinking about themes in their trials and try to boil it down to really the essence of what they think the case is about that the jury can understand quickly. And what are some of the trial themes that you've used that you thought were pretty good and effective in trying to present your side of the case?
That's I didn't have this in mind coming into our conversation, but one comes to mind immediately. And that is, and this again is, when you can't, obviously themes are not, you don't use the same thing on every theme on every case. I mean, it's rare that you can reuse a theme, although, in jury selection, you're always going to have the theme of avoiding sympathy and the burden of proof. And there's always, legal
Right.
tenets you're going to really emphasize. But I tried a case, I think it was in 2022, and it was a fatality case, and it was outside of Sacramento. And the fact pattern will explain to you why we chose this theme. But it was a very unfortunate case. It was a multiple fatality case, and it was a ride share app I was going to say who it was, but I better not.
Yeah.
The rideshare app driver was involved, and so it was an auto case, not particularly exciting, except for it was the rideshare app driver was cutting across Highway 99, and that's because he had gotten lost when it was his first day as a rideshare app driver,
Oh my goodness.
and he had no training, and he was very fresh in the country, and he had two people in his car. I'm trying to remember the details. It's going back a little bit. He had multiple people in his car, and two of them were killed. Um,
Mm.
and I had another driver that was driving down Highway 99, and the drive share app driver drove right across in front of my driver, who was exceeding the speed limit. And it was a horrible collision, and two people died, and the driver had a brain injury. So, there were lots of handles on that case from liability and damages standpoints. But when we were preparing the case, I'm going to give my partner Ashley Myers credit for this. She said, this accident never happens if the guy wasn't lost. I mean, if he knew how to use his GPS system that he had not been trained on particularly well, or
Right.
had caused some confusion, because he was on the wrong highway. He was almost in the wrong county. He was nowhere near where he was supposed to be. So the theme that Ashley came up with, and because she did the opening, she said, this is all about being in the wrong place at the wrong time. And
Mm.
if he was not in the wrong place, then it wouldn't have mattered what our driver was doing. And so we really use that, and then as the cases go along, your themes develop. Sometimes you have a theme that just evolves, as the trial unfolds. And by the time you get to closing argument, you've kind of gone into a little bit of a different direction.
Yeah.
So,
That,
uh,
that
and
can certainly happen. Well, that's great. Let's go to this question that I like to ask folks, and that is, you've tried a lot of jury trials. In your experience, what part of the jury trial is most important and why?
I think it's got to be jury selection. And first, you're making a first impression during jury selection. And I
Right.
think making a first impression is really crucial. Um, and I've already mentioned at least once how important credibility is with the jury. And I think it almost goes without saying that if the jury doesn't think that you're being forthright with them and acknowledging your weaknesses and confronting the evidence that you're going to be dealt, or that the jury will see, then you're not doing your client justice. So, and it is, I have to say, I think selecting a jury is about as much fun as you can have in trial. Closing argument probably is second best for me. Cross-examination is a close, 2B or 2A.
Yeah.
That's, I think, in terms of the things that are most rewarding, I think it kind of goes in that order for me. And the other thing that the reason I also emphasize the jury selection is that it's, you're educating yourself and you're educating the jury pool at the same time.
Right.
Because, if you treat a jury pool like I am right now, where I'm talking all the time, you're not doing your job. You want to get in front of them and make sure that the jury appreciates that you're going to be straightforward with them and establish credibility. But you really want to learn from them more than you're trying to teach them anything, right? And we've all heard
Right.
about how, you're really deselecting as opposed to selecting a jury. And, it's been very informative to work with really good jury consultants that help you understand what needs to be done to draw people out and what needs to be done if you are going to get them work on a cause challenge with them, and what kind of magic language you need to use in order
Right.
to convince the judge that's going to be the right result with that particular juror. And it's it's the process, because then when it comes down to picking, the exercising your challenges, it's like a chess game, and you want to try to save a challenge till the end
Yep.
if possible.
You want to try to get ahead of your opponent, don't you?
Yeah, I mean, that's, jury trials are all about competition. I mean, life's about
Yeah.
competition. It's really a good, if you like to compete, and that's kind of why I got into uh, civil jury trials to begin with, is because I do like to compete. And I think when you're picking a jury, you're competing right out of the gate, and
Yep.
and it can be both rewarding and fun.
Well, let me ask you this. We're talking about one year picking the jury, and you've already told me that you've worked many, many times with a jury consultant. So from your perspective, how is it that you're trying to establish a rapport, get to know these people, get them to reveal themselves to you? And then how are you also trying to get information when you think you need it that might give you a challenge for cause? How are you doing those things?
I don't know if this is technically a system, but I do have kind of a protocol that I follow when I'm selecting a jury. And I'm not one of those people, and I admire people that have the ability to memorize names and to be able to, use a juror's name. I think is a really great tool if a trial lawyer can do that comfortably,
Yep.
because that, you then the juror really feels like you're paying attention to them, and they're going to like that. And we've all seen how when a juror comes into a courtroom, like their goal is to get off the jury, right? I don't want to be here. I've got other stuff to do. But if you make the selection process interesting enough, and I'm saying entertaining kind of with air quotes, because I think it's very important to engage people, and that can be done with some level of uh, entertainment, not in a make them laugh kind of way, but keeping it interesting, I guess would
Right.
be a better way to talk about that. And so my shtick always starts with talking to the group collectively, and I have an idea. I mean, in almost every case in the last 7 or 8 years, every case is at a jury questionnaire. So you have information. You're not just kind of winging it when you get there. Almost always you've got a little sheet on somebody about knowing what you can talk about with them or what might be something you want to learn about from them, either to spread the theme around to the rest of the jury, which is something that always can be effective, or to see if you can get a cause challenge from that particular juror. But I generally talk to the whole jury or to the panel. Usually it's a six-pack method with 18, but there's judges are doing all kinds of different things now. So I don't think there is a rule of thumb about how many people you're going to voir dire at once, but
Right.
talk to everybody at the same time and get them into the raise my hand thing and get them to raise their hands about stuff so they start to participate right away, and then go through and try hard to talk to everybody about something that's meaningful and not inconsequential, but maybe something that they want to talk about.
Hmm.
And you can kind of tell. I mean, they're gonna, like you asked me what's my, people know what they want to talk about, and it, I think will tell you more about themselves if you just give them the microphone than if you're trying to draw stuff out of them. Depends on the personality, and obviously you have to kind of make adjustments along the way. But one thing I do that, and for whatever reason, my language is it's not my love language, but my language is I speak in sports analogies, and for whatever reason I'm comfortable doing that. It's okay. And one thing I will say also on the issue of comfort, I think it's really important to be comfortable in your clothes. I mean, literally, not wear a fancy suit during jury selection, but wear something where you feel comfortable.
Yep.
Uh, I know that sounds like a petty kind of thing, but I say that to myself all the time. Like, I don't feel comfortable. And maybe in closing argument, you put the fancy suit on, but for jury selection, I think you should be a normal person speaking to somebody like they're in your living room. And so when I'm
I
speaking,
actually think you should do that throughout the trial.
yeah,
Speak
and I
like a
usually
normal
do.
person.
I do kind of save the blue suit for the end usually.
Yeah,
Because that's formal and you're kind of wrapping things up, but
right.
that's just one of those uh, you just get into habits like that when you're trying cases. But speaking to the jury in general, and I do talk a lot about it in sports analogies, and one that I say at the outset is, we're trying to determine whether you're pulling for one side or the other. And if you were at a baseball game right now, you could look at the hat somebody was wearing, and you'd know if they were a A's fan or a Giants fan. But I don't know that. And, we don't want people who are pulling for one side or the other. You're basically like an umpire. And so I just want to learn from you if you are favoring one party versus the other right from the get-go. And it's not magical. It doesn't work. People don't raise their hand and says, yes, I'm not for you. But eventually they start talking and give you some information that you can hopefully use to your client's advantage.
Now, you and I both know that when you get some information from a prospective juror and you think they may be subject to a challenge for cause, um, there's a tendency on the part of a lot of trial judges to try to kind of resurrect them and save them. So, what do you do if you're trying to pursue something so you get it enough in the testimony during your questioning that you think you can actually succeed in the challenge for cause? What's your strategy?
Well, I think the trick is if you feel like you have been able to elicit a juror in a way where the juror is saying you're starting out, you're starting behind the other party. You're not at the starting line together, and the other
Right.
party has the advantage. And then the judge or the plaintiff's lawyer, depending on who's trying to do the rehab, might say, "But you'll wait to hear the evidence, and you'll follow the law," and then kind of bringing them back around. And then when you're redoing it, or if you're good at it, you do it the first time around before they rehab for whatever. Like, so let's say it's a motorcycle case, and
Yeah.
they can't be fair to a motorcyclist. And then the rehab would be, but you'll listen to the evidence, and you're not saying that you would make an award one way or the other in this case, or whatever the rehab would be. But if you get the juror to say that it's a long held belief that it would be hard to let go of, that they've had for a long time because of some personal situation that they've been in, that seems to kind of nail it down better. Now, mind you, as a defense lawyer, I want the jurors that don't want to be fair to motorcyclists typically. So I was flipping my role
Yeah.
there.
Yeah.
But I think it's that the long held belief is a phrase that seems to help judges say, yes, I agree that that's more than just his current train of thought.
Okay. Well, as you're, we've jumped into the voir dire because that's the most important part of the trial in your view. But let's go back a little bit for a second. In addition to using jury consultants, you tend to do focus groups and do things like that to try to help you prepare to talk to a jury and pick a jury. And have you found those to be helpful?
Yes, definitely. I mean, more so, um, I think that's just, again, it's a little bit like as the exposure of the cases increases, the more you really need to make sure you have a handle on the issues. And not that it doesn't hurt to lose a small case, but it really hurts to lose a big one. And
Yeah.
the prep for that is a little bit different. I mean, I'm in the case that I mentioned that I'm preparing for now. We're actually doing a second focus group. We've already done one in the county where uh, the case is going to be tried, which is Marin, and we're doing another one because things have changed a little bit. There's been we've it's a unique case. I think there's been about 50 motions in limine, half of them
Wow.
heard, and after the first half of the motions in limine, we said, well, let's do this again because the evidence that we used during the first mock trial is some of that's coming in and some of it's not. So let's put our toe back in the water. And I think those are so instructive. I mean, you can't. I mean, I'm a huge fan of going through the focus groups and the mock trials. And Cogent has done many for me, and I think the way they do it, you get so much out of it because not only are you practicing, what you're going to be doing in trial, but you're really learning that does not work. And somewhat you can get a feel for the exposure by the, kind of the verdicts that are rendered in the mock. I don't know that that's a particularly great method to evaluate a case from a damages standpoint. I mean, it helps. It's good
Yeah,
information, but
right.
it really tells you what not to do. And I remember when I did one of my first mock trials quite a while ago, one of my friends, Rich Schoenberger, said to me, "Good luck losing your mock trial." And I was like, "What are you talking about?" He goes, "Well, unless you lose, you really don't learn anything." So,
That's a good point. Yeah.
yeah,
So
that's,
when you're doing the focus groups or mock trials, are you trying to learn generally specific things? Like, are you trying to see how they're going to react to defenses, or you're trying to uh, figure out, themes, or do you do different things because you're getting different information in different cases?
it's really, usually you're testing arguments
Yeah.
and somewhat themes. A short war story, maybe, or maybe slightly longer than short. I had a case. It was really a fascinating case, and it was very unfortunate. It was a fentanyl overdose case, and it was outside of Truckee, so it was in Northern California, and I'm trying to think. Oh, that's Nevada County, and the facts were interesting. There was a person who had a really bad drug habit, and he ingested some fentanyl, and he OD'd. He died, and he was a trust fund kid who had tons of money, and he was living up at a house that was owned by the estate that was also a defendant. And after he passed away, um, the family arranged to have somebody come in and clean up the house afterwards. And there had been a hazmat team out there. The police were there. It had been a crime scene. And then once it was released, basically a house cleaner went out there, and there was a team of two people, and one of them was exposed to fentanyl that was in the carpet and died. So it was
Wow.
really, and it was a really emotional case because the plaintiffs were her two kids that she was raising as a single mom, and we got to test all kinds of stuff out on during that mock trial. And because we thought we had really good defenses because I represented the decedent, right? And the estate was involved, and there was another cleaning service that was involved, and it was a pretty complicated story. But we thought, well, how did the dead guy? How is it foreseeable that somebody would come in after he died and ingest through, just through the air? And they were vacuuming this area, and it came up, and that's what caused the death. And so we thought we had this great foreseeability argument, and the jury hated my guy in the mock jury. They were like, "We don't care what the law is." They didn't say that, but that is definitely how they acted. So, really eye-opening. No, that argument isn't any good. Don't even try to make that one. So you
Yeah, I
learn.
think focus groups or mock trials are great that way because we get caught up in our arguments, but it may not work with the jury because they're just coming at it from a different perspective.
Right.
Totally different.
Especially when there's sympathy involved,
Oh
and
yeah.
the way we settled that case, if you don't mind, I'm going to tell the story about how we settled that case. At least my piece of it there was a lawyer out of Texas that was like a fentanyl lawyer, and he had his own shtick, but we were using a really good mediator. It was Matt Conant was our mediator, and we were going to mediate in person at his office. And I'm not sure how I came up with this or how exactly this happened, but I said to the plaintiff's lawyer, I don't want to take your client's deposition. She was like 8 or 9 years old, or maybe 10. I said, but I'd really like to meet her before the mediation. Would you be up for that? He goes, sure. And I said, okay, well, that's great. Why don't we met for lunch at some place in Jack London Square, real casual place. And we sat down and talked, and the kid was precocious and cute and really nice. And I mean, she was just a right out of central casting. And the we got a rapport going, not only with the lawyer, but with the kid, with her guardian, because their mother had passed away.
Yeah.
And it was real and very unusual. I don't haven't done that too often. And I don't think it was my idea. I think it might have been the plaintiff's lawyer who said, why don't we get together before the mediation? And it was, being able to communicate directly with even a kid and her guardian in an informal setting, it just set the stage for a much better outcome than a lot of times when you're in there talking about foreseeability and things that jurors don't necessarily listen to.
Well, that's a great story. I mean, I think whether it's you were able to connect as people and build a personal connection, and that made a big difference in that mediation.
Yeah.
Totally makes a big difference. So, one last thing I want to ask you about voir dire. We've got, baby boomers are aging, and then you've got the other generations behind them, and you're starting to see probably more often some of these younger generations like millennials, Gen Z, and others. Are you noticing differences in the jurors who are in the younger generations coming up and now serving on the jury trial, or do you think they're acting similar to what jurors were doing 20, 30 years ago?
I think I mean, there's a lot of issues in that question. I mean,
Yeah.
because first of all, and when I'm picking a jury, I usually have a little bit of a formulaic approach to who I'm looking for, which is highly educated, high income, and then it depends on who my client is for the rest. Uh,
Yep.
Somebody in management, generally we think of them as defense jurors, and it's a little bit harder to identify that model in a younger juror. Um, and so that is a challenge because that's the immediacy of information that they're used to. And you really have to keep their attention in a different way because that's what people expect now, right? You can use, I mean, I think low tech can be good with young jurors if you don't overdo it, but
Yep.
I mean, it can be real simple. Um, but, and that's the beauty of having a jury consultant because they can help you maybe not relate to, but maybe communicate with the potential jurors. I mean, and who you're trying to stay away from in a particular case might have a lot to do with age. So I'm not sure I've given you a good answer there because I do think you got to be armed with information when
Yep.
you're talking to any age juror. And that's what a great jury consultant can help you with, I think. And it's funny,
No,
I will say also that some people, I know some really, really good lawyers that don't use juror consultants. They're like, I know what I need, I know how to get there, and more power to them. That's part of my team concept. I really feel like it's great to have affirmation from somebody who's either a social scientist or who's understands what the process is all about, just to keep you in your lane, to make sure you're not veering off the road.
and I guess maybe one final thing to go with that consultant, and that is, let's say you're picking that jury and you have a situation where you think one thing about a potential juror and the consultant thinks another. Who makes the final decision?
Well, ultimately, the trial lawyer has to. But
Okay.
this is, and I engage my client in jury selection to some degree. I rely heavily on the lawyer who's trying the case with me as well, because there's got to be collaboration on that. But ultimately, you make the call, and you take all that into effect or into account, and then decide what you're going to do. But I definitely can be persuaded. And people have different perspectives. That's the beauty of trying a case with somebody who's younger than you, different gender, different perspective. It really helps make sure that you're not completely whiffing on stuff. Hopefully.
Okay. Now, when you're in the voir dire process, the mini opening, and all that, one of the things that your opponents on the plaintiff side are constantly doing is they're trying to start talking to the jury pretty early about whatever the damages are. And usually they're not going to be in a trial unless it's big damages. And they may be talking about big, big numbers. Um, and from your perspective as a defense lawyer, have you ever seen something where you thought that either the timing of how early they brought up the numbers or the way they described it kind of backfired from the plaintiff's perspective of what they were trying to do?
Absolutely. And I'm thinking of one case in particular in Santa Clara County, which is a fairly conservative venue. And this again was on the tail of COVID. And I'll tell you, that was the only reason I bring that up is that the judge, there was a microphone that was passed around through in the courtroom because again, they were in the audience.
Yeah.
There was it was a death case, and the there's a I don't I'm trying not to smear anybody here. There is a Los Angeles lawyer who's the plaintiff's lawyer.
Okay.
The judge said that I'm going to, because of the need to pass the microphone around, I'm going to have the, after each juror is voir dired, then the defense lawyer can go next, right? So, which was really favorable for the defense because you've seen and you've probably been involved in cases where the plaintiff's lawyer gets a great momentum going because they're engaging everybody and they're getting them on their page and they're kind of educating them and informing them about the issues. But when the defense lawyer can get up after the first and then start to undo everything,
Oh, yeah.
that was a real advantage for the defense. But the reason I'm thinking about that case is almost the first thing out of the plaintiff's lawyer's mouths had to do with how many millions of dollars he would be asking for. And I think it's smart to anchor the jury if the judge will let you, but the bedside manner on that one was really not well received because it wasn't about why damages were so high or the reason that the family was entitled to be compensated. It really was right for the money, and I thought that was a real bad way. That's a bad first impression. We're talking about making a good one. You can make a bad one too.
Right.
So I thought that backfired.
Well, now that brings me back to another thought. You mentioned earlier credibility. And in my experience, I agree with you. I think credibility is probably the most important thing in any jury trial or judge trial. And you mentioned your credibility. So I agree with you. I think the trial lawyer's credibility is paramount. But you also have to have credibility in your witness, credibility in your client, credibility in your experts. It's important throughout all this part of the trial. So is that your experience in the courtroom?
Totally concur. I mean, obviously, when we're evaluating cases, this is kind of going back to when a case comes in, we're looking at uh, really three major things you could tell right away. Number one, where's the case venue? I mean, that's going to make a big difference on value.
Yep.
Number two, who's the plaintiff's lawyer? I mean,
Right.
that makes a huge difference in, how the case is going to be not only handled and tried, but also what it's worth. And then number three is like, how is the plaintiff, going to sell? And the flip side of that is, how's your client going to do?
Yep.
So it's all about really credibility of the plaintiff's lawyer, credibility of his client, credibility of our client. And then you wait to see who the judge is. Sometimes it's single assignment, right away. And then you got all four pieces of information that you need to evaluate the case and whether you should
Yeah.
run for
That,
cover or run to the courtroom.
that's critical. So and interesting on the defense side, see the plaintiff's lawyer gets to pick their plaintiff. If they don't like the plaintiff, they'll say no to the case. You don't have that luxury.
That's true. I'm trying to get there, but it's just, you don't have
So
that luxury. But that does it. That influences which cases you become determined to try. Like
yeah,
you got a
right.
great client. It's like, oh, they're going to love this person. Like
Yeah. If you've got a client who you're worried about their credibility, you're not going to be as anxious to try that case.
or if you try it, you're not going to sleep as well at night.
Yeah, you are not going to sleep as well at night. So now we're not going to talk about everything we can talk about with a trial, but in terms of your, let's say, cross-exam, which you were talking about as one of your also pretty favorite things in trying a case. Um, in terms of your cross exam, do you tend to just try to use the classic closed question, control the witness, don't let them wiggle or move much? Do you vary the kinds of ways you do your cross? Because sometimes people do some crazy open cross where all kinds of stuff can be talked about. Or do you tend to favor one or the other? Do you use things in different circumstances for cross?
I mean, I think everything, again, it depends on the witness. Cross-examining an expert is entirely different than cross-examining a lay witness because
Yep.
the experts know what's coming. They know all the tricks. They know how to add information after they've finished responding. So that's a little trickier. With them, it's pretty much strictly closed-ended everything.
Yep.
Um, and asking the judge to admonish the witness for being non-responsive if they add things in there. With lay witnesses, it's a little looser for me. I mean, I think the keys about cross, which I think everybody's seen who's that guy that did that? There's a videotape that somebody did a long time about cross-examination. Can't remember right now. Never mind. But starting your cross with some impact evidence and closing it with, the crucial evidence, knowing what the answers are, of course,
Yep.
but having taken the deposition, you're gonna know. And then in between, there might be a little bit loosening on whether it's a closed-end question, depending on how it's going. And it really, cross-examining a sympathetic witness, you have to be delicate, and you can't be too aggressive or step on toes because the jury's going to get mad at you. So it really sometimes you don't cross-examine for that very reason because of the sympathy. So it is
Right.
for sure witness dependent.
But I think there's also an art to the cross exam in terms of you can be asking questions in a way that's very courteous and friendly, and I think you need to. But yet the other side, the witness looks like they're not telling the truth or they're being evasive. You don't want to be attacking them and trying to destroy them because the jury can get mad at you.
Right. Yes, I'm with you.
Okay. So in terms of, let me ask you this about 776. In California, we have this ability that the plaintiff's lawyer can cross-examine the defendant right out of the chute and all of that. But it seems to me, and I've done this representing plaintiffs, but I've also benefited representing defendants. You can get some benefit if the plaintiff calls your witness right out of the chute and they're cross-examining them because you can start telling your case in your direct exam after their cross. And do you find that to be helpful and effective when the plaintiff calls your witness early?
I do. I mean, we're always, you have to always be ready for that and have your client prepared for that, obviously. One of the things that, a decision that has to be made by the trial lawyer at that point is whether you're going to reserve or do your examination right then. A lot of times, I mean, many times I'll defer, so I'm not really getting my side out there at the beginning because I might need my client to clean a bunch of stuff up at the end. So I think more often than not, I just defer my direct because I figure I'm going to need to recall my witness, and I don't really want to put a client on the stand twice if I can help it. So that's kind of my default is waiting to see what issues might come up that need to be clarified by the client at the end. And if it's a really good client, then I want my client to be up there at the end anyway, so the jury is thinking about my client when they're deliberating.
You want them later on in the case, closer to deliberation time. That makes sense. So now one final thing about cross, and that is when you're trying to impeach a witness, you got different ways to do it. So you could read from a depo. You could show the depo transcript up on the screen. You could have a video clip. Do you think certain ways of impeachment are more effective in getting through to the jury, and why?
I think in today's climate with the internet and everything being available at your fingertips, you could almost ask Siri what the jury verdict's going to be, it seems like. But I think today it's almost expected that you use video to impeach. I find that a little bit cumbersome. I think I personally like to mix and match things, like either reading it, showing the text, or showing the video.
Yep.
And maybe with, I'm not sure that you tier it so that the most important things are on video, but I do the same kind of thing in closing where I use a PowerPoint, uh, a whiteboard, some hard, uh, you know, graphics. So I think it's good to mix things up, but I
Right.
do think in terms of cross-exam, people want immediacy and they want to look at things and they don't want to necessarily only listen.
Okay. So in your final argument, when you're doing your closing argument, what's your strategy of trying to get the jury ready to fill out that jury verdict form in the manner you think is right?
Just
And
show, just show them how
remember,
to do. You just show them how to do it, right?
yeah, you want to go through it.
Yeah, every closing argument with a special verdict is completed. I do the numbers. If I'm arguing for a defense verdict, I don't write any numbers down, obviously, but literally going through question by question and emphasizing from the defense side, if you answer question number 3, you're done. You can go home and enjoy your weekend. It's really obviously you're going to lay out the elements of the case during your comments, but then literally, and I always have that on poster board. I don't use PowerPoint for that so that you could just use the black marker to check or X the box that you want to be completed in the way that would be good for your client.
Now you mentioned if you're arguing for a defense verdict. So let's say this: if you've got a significant liability issue and you think your client should have a good chance to win on liability, do you not argue any damages in that kind of a case?
No, the distinction I would make is that I will give the jury, I usually will go through my liability argument and then suggest that that's the way we believe the evidence has been presented and this is the determination you should make. But you might have seen things differently. And if you did, and I'll talk about damages, I'll give them a number to that would be more satisfactory than what's being suggested by plaintiff's counsel, but I won't write that down. I won't write, that was what I fill out the special verdict with a black marker, but I don't put any numbers in there unless it's a 0.
Okay, so what you do is you'll fill out all the stuff and go to the liability issue. You won't fill out anything related to damages, although you'll talk about it.
Exactly.
Okay, well, that makes good sense. Well, listen, Chris, this has been a great conversation. The time flies by, and you've really given a lot of good information that will be helpful to people. I want to finish up our conversation with this question. What kind of advice would you give younger trial lawyers who are just want to become good trial lawyers and want to learn? Maybe it's something you were advised when you were young. Maybe it's things you've learned throughout your career. But what would you tell a young lawyer who wants to become a good trial lawyer? What advice would you give?
I think I have 2 pieces of advice. The first is that find a role model. It's great if the role model could be in your firm, so that you can kind of learn by doing and following and seeing. Sometimes that maybe it doesn't work that way, and maybe you have a role model that you just want to emulate in the way they handle themselves in a courtroom. So I think that's really important, is finding a mentor. The other is, and this is maybe a little bit more practical, and it's for sure, this is a defense directed to the defense lawyers of the future, and that is, don't evaluate your cases so that they settle. Because if you're dealing with an institutional client, whether it's a corporation or insurance company, and they're obviously always thinking about the bottom line and how much it'll cost to defend. But if you can shape cases so that they settle, you can over-evaluate them and pay too much money. But if you want to get into trial, tell the client, don't pay any money in this case. I can't guarantee you we're going to win, but we can get a good result here. And believe in your client, believe in yourself, and don't fold all the time. I mean, it's easy to do that. It's easier to sleep at night when you're not in trial for 7 or 8 weeks.
Yeah.
That could be a shortcut, but it's, that's, if you want to be a trial lawyer, you have to put yourself in a position to try cases, which means don't try to settle everything. So I know that's kind of maybe oversimplified, but people do that. People evaluate cases to resolve them short of jury trial, and then you don't get to trial. Then you don't
Right.
get into a VOTA.
Right. Well, listen, that's great advice. And thank you so much for being a guest today. Thanks for all the work you've done at ABOTA and the other organizations over the years. And this has been great. The people are going to learn a lot of things from this. Thank you very much, Chris. Really appreciated your interview and your advice and your wisdom today.
My pleasure, Marty. It was enjoyable. Thank you.
Thank you.